Good afternoon. Welcome to Payentry's biweekly webinar on a hot human resource issue. Today's webinar is about the most common mistakes made by human resources professionals or anyone else given the responsibility for that particular area within the organization. I'm Cathy Graham. I've noticed some of your names as being repeat people who have attended the webinars, and I really do appreciate your being here today. It's my job to bring out this kind of information and make sure you feel comfortable with that part of your job. Today we're going to go through an introduction to HR mistakes. We're going to look at those mistakes that are made by HR and how to avoid those, keeping your company out of trouble. Just as an introduction, common mistakes are preventable when you're taking a proactive approach. Now, I know if you're in payroll, human resources, or all of the above, it's hard to be proactive because you don't feel like you have the time to do that. Planning also is something that if you're reacting to the everyday issues that you're dealing with employees and payroll and other things, that it is hard to sit down and plan. But that is one thing that will help you prevent some mistakes, and we'll talk about that more when we get into the presentation. Also, appropriate training. That's not just for you, but it's for your supervisors. A lot of times, HR mistakes are not made by the HR person. They're made by someone that's a direct line supervisor or a manager in the department. The mistake number one is an outdated handbook. If you have a handbook, this question comes to mind: what's worse than having no employee handbook? Well, it would be one that's not accurate or not current, because that can do a lot of damage. I'm so used to, in my prior responsibilities for things like this, being in a room full of people and being able to see your faces and get you to raise your hands and say how many of you have ever had a problem with a handbook that wasn't accurate. I do miss that part of it, being able to quiz you on this. But I know if I asked right now for you to raise your hand, if you have a handbook that is either non-existent, not accurate, or current, probably a lot of people would raise their hands. And that's not uncommon because you are busy and that's the last thing on your list, and you'd love to get to it, but getting people paid and other things done is more important, more critical that day. So an outdated handbook, the typical issues that come up with those types of that type of problem is that in there you don't have any disclaimers about employment contracts, about promising continued employment, or the right to alter your policies. Sometimes there are handbooks out there that actually have promissory language in them that's perceived as contractual rights, like language like, we want you to work here and be happy as long as you can. Something like that in your handbook is deadly, because that could be perceived as a contract of employment. You also may have an inflexible progressive discipline policy. If throughout your handbook you use the word will when you say, we will take disciplinary action, up to and including termination, which is the normal clause, you are locking yourself into having to do that or having to go through the steps of a progressive discipline policy when you should use the word may. You always want to be consistent when you're applying progressive discipline within your organization, taking the steps, the written, the verbal, the verbal, the written types of notices that you give people about bad performance, but you want to leave it in your handbook as something you may or may not do. And failing to update your policies to comply with new laws. I'm sure since we do have a presence throughout the United States with clients, we may have people on here that are in California or New York, Illinois. There are laws in almost every state that have changed this year concerning paid leaves of absence or drug testing or the type of application that you can use for new hires. Those lots of things change on an annual basis. So your handbook needs to be compliant with the current laws. And then if you adopt a handbook that you find on the internet, it's not a good idea because one handbook does not fit all, like one size does not fit all. You have state laws that need to be inserted in that, and you're not sure exactly who might have written that handbook and whether or not it's truly should be a legal document. And then if you in your handbook ban your employees from talking about their salaries or the personal use of company email, things like that, that could be considered a violation of the National Labor Relations Board, the union. If you have a union or even if you don't, these things can target you for types of union activity. So there are a lot of little things too that need to be updated. And if you don't include current EEOC or anti-harassment statements, California has some new laws, so does New York City. There are a lot of different states that are changing the laws, and you have to have that in your handbook. Also, this is one that catches a lot of employers. If you have missing or outdated vacation or sick payout policies, in most states, you do not have to pay out vacation and sick accrued if you say in your handbook that we're not going to pay that out unless you give us a 2-week notice, or we're not going to pay that out, period. If that's not in your handbook, in most states, like here in North Carolina, you would have to pay them regardless of whether they gave you 2 weeks notice or if they violated a company policy and you fired them for stealing. You would still have to pay out that vacation or sick if it doesn't state it in your handbook. Now, there are certain states, Massachusetts, that mandates that you pay out this regardless, so you do need to check your state laws too before you include that language in your handbook. Mistake number 2 is misclassifying your employees. And this is going to become a bigger deal by the end of the year because of the fact that the overtime rules are being changed and the exempt, non-exempt statuses are going to be re-examined by the end of the year by the Department of Labor. There are 2 areas where problems can happen or occur. One is in your assignment of an exempt status versus a non-exempt status. Exempt status means they're not eligible for overtime. Non-exempt means that they are an hourly person entitled to overtime for over a certain number of hours worked in a week based on your state rules. The other area where problems occur very frequently is in your assignment of someone as an independent contractor and paying them on a 1099 versus calling them an employee, putting them on your payroll, and issuing a W-2 at year end. This is a big area, and this is an area where the Department of Labor and the IRS cooperate together because the IRS wants their tax dollars. And when you're hiring an independent contractor versus an employee, you're not paying a lot of the taxes on that independent contractor that you would pay on an employee. So if you have someone misclassified, then the IRS is going to be very interested in finding that out. These are very costly mistakes. Once the Department of Labor or the IRS comes in, or both, come in and find that you have misclassified someone, they will assess penalties along with providing back pay for overtime for that individual that was working for you. Again, with the misclassification of employees, the Department of Wage and Hour Division governs the misclassification on the exempt and non-exempt basis. They have clear definitions of exempt and non-exempt status, salaried and hourly status. And it does depend on the employee's specific duties, not their title. I've worked in many places where they had administrative assistants and that person should have been hourly, but because it was deemed to be a status to be salaried, then that person was called salaried and not paid overtime. That is against the law. So in that situation, if the Department of Labor would find that, they would have to go back and look at how many hours this person actually worked, and you would end up paying overtime for that person if they've been assigned the wrong status. The IRS and the DOL together govern the independent contractor status. The IRS has a three-part test for this, and you can go on their website and find that, or you can shoot me an email after this webinar is over, and I'll send it to you. And the Department of Labor looks at 7 factors. We are going to do a webinar on this misclassification or correct classification of employees later on this year before the new rules come out. But the Department of Labor has an even longer list. So it's important for you to look at those and determine if you have any 1099 employees, you need to make sure that you are following the rules or you have defined it properly, you're employed properly. And again, how do you avoid these mistakes? Well, number one, first of all, start out with an accurate job description. That's your key right there. And make sure you review those annually to make changes. Normally, companies do that when a performance appraisal might be due. If you do those annually, make sure that the employee looks at the job description and the supervisor looks at it to see if there are any changes that need to be made. Oftentimes during the year, supervisor may start to assign additional responsibilities to someone that move them into a different category, and you need to be aware of that. Also, do a periodic self-audit of current exempt status employees, and those are your salaried employees. This is something that is very, very important for you to do at least annually. Review all of those that you have as independent contractor according to the IRS and the Department of Labor rules. If you're doing all of these things, then you will not have a problem if you're doing it correctly. So another big mistake that those who are assigned to human resources responsibilities make are with incomplete I-9s. I-9s are enforced by the Immigration, Customs, and Enforcement Department. It monitors the common mistakes discovered during an audit, and there is a lot of activity in this area right now. If you fail to sign Section 2, which is the section that shows all of the documents that the person is presenting to verify their right to work in the United States, if you fail to sign that, that is significant during an audit. If you fail to complete one at all, that's the biggest deal of all, obviously. And if you had it, but you can't find it, that's another big problem because it's just as though you don't have one at all. One thing I will tell you, keep all of your I-9s in one folder. Don't put them in the employee file. During an audit, you do not want anyone, ICE or Department of Labor or anyone else, looking at the entire folder when all they really need is the I-9. So always keep all of your I-9s together. And then failure to ensure that the worker actually signs Section 1. If you're using Payentry to do your payroll and you're using the onboarding piece of this, it will not let them pass that section without signing it. So that offers you some assistance with getting that signature. And then if you're missing list A, B, and C documents, those are the documents that are presented to verify that the person can work in the United States. That's a really big deal also. So all of these things can come up to huge penalties and some real problems for your company. So how do you avoid this? Well, first of all, be very, very careful when you complete all these I-9s. I know that it has to be done in the first 3 days of a person's employment, or you have to terminate them. So it's fast and furious when someone gets hired. Sometimes you feel like you don't know they've been hired until a month later. You need to put something in place to keep that from happening. But using our onboarding process through Payentry is one way around that, because they can't be hired unless all of this is completed. So be very careful. And then every 6 months or so, do a self-audit to ensure compliance. Go into your files and make sure things have been signed, that you have the documents that you need, and that everything's complete. Mistake number 4, and this happens quite a bit, is inadequate documentation for terminations. If you terminate someone and you're not following your company policy or precedent for progressive discipline, then and there's no documentation in the file to show why they were terminated, that's a big deal. That's a mistake. This won't get an this won't bring an auditor into your house or your company, but it can result in a lawsuit for wrongful discharge or discrimination, probably more likely discrimination of some sort. If you don't have any written documentation leading up to a termination, that is a bad, bad thing. The person that gets terminated should never be surprised, and sometimes people are. Now, if it's a layoff or a downsizing, that's different. But if it's a termination based on their performance on the job, then it should not be a surprise to them. If you do have documentation, but there's no signature on the written warning, then that's a problem. You need to get something in writing that acknowledges that you had this discussion. Doesn't mean that they agree with it, but it just means that we sat down today and we talked about this. If they won't sign it, all you have to do is make a notation on the file that the employee refused to sign the paperwork. Another thing that's something that happens frequently that should never happen is if you terminate someone on the spot for misconduct and you don't have any proof of it, that is not a good thing. You should actually be interviewing somebody and getting some documentation there. So how do you avoid these mistakes? Number 1, review your current policies and procedures for progressive discipline and termination. Make sure that they're current, obviously, and that you use may instead of will. That's a very key word in progressive discipline. Train all your managers and supervisors to make sure that there's frontline compliance, because you know as well as I do, a lot of time the managers and supervisors are the ones who get you in trouble, and then you have to go clean it up, or the boss has to go clean it up. So make sure that there's some training in place so that they know how to do this and what's expected of them. Create a form. That's always makes it easier when you're dealing with supervisors and managers. Hand them a form. This is what you use to write up the document, the problem that the person has. It doesn't have to be long. It can be something that makes it pretty easy to do, and get them to sign it, get the person to sign it. But a form that you create will make a big difference. And here's what I was talking about a little earlier. If someone is terminated immediately for misconduct, make sure that you have properly interviewed witnesses to that misconduct and documented the event. If it's for theft, you go back through the process of how you found that, but write things down. And if actually you fire somebody for fighting in the warehouse, then interview a couple of people that saw what happened so that you know that that person was actually at fault and wasn't attacked by another coworker. So make sure you have all the facts and write it down. Mistake number 5, outdated employment applications. This wasn't a big deal until a couple of years ago now, because the states now are changing what you can ask on an application. So make sure that the application that you use is current with state and federal regulations. Many of you may have heard the words ban the box. That's a term now that for laws that won't allow you to ask questions about someone's criminal history. There are about 13 or 14 states, I think now, that have laws that won't allow you to have that on your application. And if you do and someone notices it, you could get sued for discrimination. Pay equity. Many of the states now have adopted laws about not asking questions about prior salary history on an application or in an interview because it has a tendency to discriminate against females in the workforce. And then you'd be surprised at the types of applications that I've seen over the years. People will ask your age, and this not necessarily on the application, but yes, it does happen. Marital status, do you have any disabilities? That kind of thing. There are ways to ask about disabilities, but not a straightforward question on your application or in an interview. So how do you avoid these mistakes? Well, number one, find a reputable source for an application that takes your state laws into consideration. Our Get Hired onboarding piece does that. It offers you that kind of an application process where you can set it up for your state. Ensure that all your managers and supervisors know what they can and cannot ask during an interview. That's where a lot of companies get tripped up, is that their managers and supervisors are still dealing with laws or don't know about the laws that exist today. Mistake number 6, underestimating the importance of a benefit plan compliance review. Many of you may not have to deal with employee benefits, but if you do, if you enroll people and take them off the coverage and all of that, you need to be in the loop about what is actually required when you enroll someone on your plan. A plan document is a document that your company has that shows all the rules and regulations of your plan and the benefits, etc. That's not something that employees get, but each employee needs to get a summary plan description for each benefit plan. We'll go into that in detail in a minute. The other thing is that if you have more than 50 employees, you have to comply with the Affordable Care Act. And if you're not meeting the deadlines or using incorrect codes, that causes significant penalties. So it's very important to know what the rules are for your company and make sure someone is complying with those. Not filing a Form 5500 for your benefit plans. Now, Form 5500 is a tax form that you file for certain benefit, well, all of your benefit plans actually, if you have more than 100 participants on the plan, your health insurance, your dental insurance, your life insurance. That has to be filed every year. It has to always be filed for your retirement plan, regardless of how many participants are on the plan. Not providing the required notices for your health plans. You know, you may think, well, that is the health insurance company's responsibility. A lot of times they'll do it for you, or your broker will do it for you, but guess who gets in trouble if you don't send them out and you can't prove it during an audit? That would be you, the company. So there are required notices for health plans. We did a webinar a while back on these notices, and I'll be happy to send you that if you need it. Just shoot me an email. So how do you avoid these mistakes for benefit plan compliance? Well, make sure that you know where all of your documents are, because if an auditor comes and schedules a session with you, that's the first thing they're going to ask for: a copy of your plan document and a copy of your summary plan description, not just for your retirement plan, but for each one of your benefit plans. Make sure all the current participants have received a copy of what we call the SPD, which is the summary plan description. That is not the little booklet that your insurance company gives you usually, or an overview of the benefits. It's a much more detailed document that shows where they can file a claim and what their ERISA rights are. If you need more information on that, I'll be happy to share that with you. Or you can talk to your broker about getting that for you. And back up to current participants. Current participants, well, this ensure that the receipt of an SPD is automatic upon enrollment in the plans. You actually have 90 days to give someone that enrolls in your plan a copy of that SPD. Set yourself up a calendar for compliance if you have to comply with the Affordable Care Act and any other benefit plan notices that are required throughout the year. For example, there's a notice that's required by October the 15th of each year, and it notifies your employees whether or not your plan is creditable according to Medicare. Has nothing to do with Medicare really, but uh, the webinar that we did before gives you more information about that. I'll be happy to send you something, or your broker can help you, but there's a notice that you as the employer are responsible for sending out to let your employees know if your plan meets government criteria for prescription drugs. And determine who in your company is filing the Form 5500 if you have over 100 participants on any of your health plans or dental plans or life insurance plans. Mistake number 7, and if you're a new HR person, this is very easy to do, and HR people have long been criticized for that, and that's losing your balance. That's taking the employee's side in all matters. If you do that, your management's going to see you as an employee advocate, not a business partner. And in today's world, HR people want to be a business partner. You want a seat at the table. But if you always take the company's side, then the employees don't see you as an advocate. So it's very, very important to consider your position and do that constantly. Balance is critical to your success on both sides of that fence, and that you do kind of ride the fence sometimes. How do you avoid losing your balance? Well, number one, it's basically a self-check periodically. How do you think you're doing? Then look at your current projects and assignments. Who's going to benefit from those projects and assignments? That's one key right there. Ask others for feedback, and I'm sure they'll give it to you because people love to tell you if they think that you're being favoritism. Review your HR practices regularly. Use outside counsel or experienced HR professionals to do that. Make sure that your managers and your supervisors have read your handbook and implement any training that you need for critical policies and procedures. There's some state mandated training in California and New York about sexual harassment, and that's going to I think Massachusetts may be requiring it now, but that's getting broader. So those are things that you need to be on top of. And this is just overall guidance on how to stay out of trouble, basically. Communicate your changes to the employees as those changes occur. And that way, you can use those changes or those memos that you communicate to employees as addendums to your handbook and not have to rewrite the thing every 6 weeks to communicate a new policy or a new practice. And then request feedback from both management and employees to see if they, everybody's got a complaint. Nobody gives you positive feedback. I always have said that payroll is the most thankless job in the world, and I think HR is right there next to it. So, but make sure that you keep your ears open and that you know what's going on around you. That's the end of our session today. Thank you for attending. If you'd like a copy of today's presentation, I will be happy to provide that to you. Just shoot me an email. I'm opening up the chat room right now, the chat box on your system. And if you do have a question that you'd like for us to address now before this session is over, we'll be happy to do that. Or you can send me an email afterwards, but it is open now. All you have to do is click in and type your question, and I'll be happy to answer it for you. Courtney asked, will the slides be available to us? Yes, they will be. We do keep them. This is a recording, and you can pull it up and listen to it again, or someone else in your company can do the same thing. Or I can send you a copy of the PowerPoint in a PDF format. Okay, so that ends today's presentation. Thank you very much for being here. I look forward to seeing your name on my list. I'm making up faces for each one of you, but hopefully someday I will get to meet some of you. But give me a call if you have any questions. It's part of the entry service to have me as an option for answering questions that have to deal with HR. So thank you very much and have a great day.